I'm gonna take between Zadal and Dick.
He's gonna sit here.
There's
more space.
Yeah.
There's more space. I also think he might let like Emery have their own, you know, like.
Yeah, we gotta like a thing going on over here, yeah.
I think.
Oh! Wow!
Oh shit.
Yeah.
Wow, that's gonna cover it.
Wow.
I can't do anything.
What? Can I? What did you say? Yeah, I turned it on.
It's on.
It's good. We're good. Okay.
It's okay, take your time.
Yeah. I'd rather you like meet up before we let this fly. Yeah, we're good.
Okay. You're good?
Okay. Actually, sorry, one time. Actually,
You guys didn't send me out here, right?
No.
it's new.
Yeah.
So look at his face, it's like Christmas.
Save that thought.
I don't have to cut it. Yeah, wait, one second. Hey, can you send me a phone upload? I need.
You want paper?
No.
Oh.
So I just saved it. One second.
Yeah. See, let's get through.
No. Listen, you can stand here all day.
I'm good.
The 1AC was sent. Did everyone get the 1AC?
I had internet issues. Sorry. I know it's your point. Go.
Hey, Michigan, I was up here.
We're good. Everyone's good. Cool. Content to what is the moon? Workers in the U.S. on temporary assignments to the moon are the limits test for jurisdictional uncertainty and enforceability of labor rights, perception of uncertainty, locks and flex convenience and rights of the law, and ensuring membership tech for 21. A British conscious for American citizens was the because sponsor American petition of British company and edible company headquartered in the UAE just representation of virus and others or lots of other state rights can enforce the use of most like an IGEs and operates the moon bureau treaty functions exclusively and take control of the artists course given the repeated refusal to join and thought I love result race level all countries registered in states of possible and for more exploitation of labor expanding facts and getting species requires to uniform country and other possible for most secret individual hospital laws because rights track drastically different from one match to another would potentially lead to similar work conditions give jurisdictional uncertainty for arbitrary sort of contracts have to be litigated pursuant to very ethical law method and determination of jurisdiction mean whether or might not even exist while the strike price and dress no one has to make complete you'll be optional whole division as collateral negotiations task cases or similar later disputes if there's no mechanism to enforce workers' rights in space that's an urgent problem given Trump's push for privatized lunar nuclear bases by 2030 1 and 25 the U.S. will realize that humans in the moon in Trump's for lunar base nuclear reactor needs deployed ability to attack and respond to security threats by that destruction competition for bases shrinking let's expect government investment by easy regulation from non-GDL companies will participate in strong companies that are physical possibility of destruction to see that from moon on data center transport from the SAC government and check by the one industrial ecosystem on the moon and will petition transfer to companies Trump's push to establish facts on the ground before legal jurisdiction is existentially self-defeating. It jeopardizes safety and leadership by losing key workers to recruitment or subversion by adversaries like China, risking catastrophic nuclear accidents and sabotage during cold lunar competition due to hot terrestrial war and locking the global economy out of lunar resources for its growth and 25 percent between U.S. strength nuclear reactors in the world means by functional sovereignty over resources of China, skipping military risks can be high huge plus ice. The other three until the future versus energy most important is to reduce space damage, quickly turn military actions, take to keep competition from nearby resources, special factors, control that thing started the first nuclear space crews, fake colleague, defensively leverage across complex news will second version counter, the cyber countermeasures confirm that escalation of lunar nuclear very fragile, integrated partners, deployment, but also delegate security tasks, companies, actors, power protection, change about the power, nuclear infrastructure needs specialized sandwich, makes it vulnerable to attack this all of the space, nuclear engineers, the charter agreement, this issue, is likely to be with the authority chains, made major commitments for decades, facts for government, put one risk for security and IR, intel say, China nuclear on the moon, heat ability to compete permanently goes away the short system space all in reactor security hosts not found on our side social form we're expanding aerospace law we're taking constructive questions that need to hire people who know about space and nuclear tech or very because there aren't many fact whether democratic societies say to stop this successful failure that facts that people think about community governance for else applications of firms will change bounds over hundreds of years of age like the traditional failures to set back government development by decades and schooling social complex of facts that would facts for governance roots and have not heard call these should not competition remains for the debate of stability and peace human civilization when it hangs to the balance. Reactors must use HEU, creating catastrophic risk whether from accidents, lunar proliferation, or lunar terrorism, good for nuclear. On the moon, these HEU giving utility for weapons that the countries such as China have see terrorism on the moon, even more about every custody of accidents will become nuclear waste count. Place that any cause extinction from tidal failure or rotational shift or debris beyond 1024 nuclear reactors that will lead to total collapse by no with disorder, food changes, rotation with start freezing and fire and debris and small fire releasing kinetic energy in the atmosphere, heating all life, and all life is celebrated by conscious chain reaction which choke about planets on axial tilt this harmonize one hemisphere perpetual darkness the sky left hint at comics and common infrastructure sometimes work so should be the idea for organizing labor and non-violent structure and safety workers are powerful engineer solutions to ensure make a way to make forces show without turning safety belt tolerance construction to be built in the legal system to the moon to private to monitor private mining offices a stretch to imagine how imagine being used response to complicated paradation to combat who doesn't need new construction in the bottom of the gravity well can drop off the kinetic entry cause strong conscious extinction extraterrestrial wars that can extinguish humanity altogether and lunar sabotage provokes escalation to existential nuclear miscalculation and compass and 24 the first time the natural team in space America's making sure they try to reach the privacy in space opposites and advantage until such time ability sets it order weapons training documents we can using override strikes in space to force early capitulation and sequence bases for game showing buddy regulation can drive ever related conflict in space and for strategic insurance grab taking away from Earth into space makes dangerous miscalculated prospect for obstacle gray zone tactically like cyber tech escalation following interference to be intelligence and impending nuclear attack China's lunar agenda is revisionist and will be leveraged to monopolize lunar resources in pursuit of territorial aggression of global hegemony and threatening homeland threats to the U.S. which goes nuclear burden with its 23 lunar infrastructure means by which the CCP increased power some scholars are estimated that the global audience for CCP is one competition over lunar increase as SOI over other states they say global audience increase as activities become more aggressive to the ILRS to activate the transition to set president to law for to justify conflict armed forces creating territory on Earth and in space versus Taiwan and islands water morphine laying guys but no people rules or international body language trade provocative actions of serious shock that's by covert ops and commercial control of the great zone and monopolize rules resources to work for your company with receivable future evidence United States system as a force multiplying all the names to put weapons against targets the U.S. homeland and fighting both the CCP space ambitions rule and lose confidence in Washington's resolve of political security agreements when unright returns on arrival alliances specifically Christ between nuclear armed powers apologists of wrong Richmond in 25 days and 100% and works on the North related to China bricks are local responsible religions resources increasing violent aggression to LA post sexual blow and reflecting a democratic piece of development the same perception of the backside going for little base and the liberals of ours neither alternative deal and very equality climate change more critical claims camouflage and subservience to cardinals below order risk existential conflict evidence by rapid increase of war. Now, near-term access to lunar resources check, human extinction to escalation of fossil and mineral-driven conflicts, nuclear, AI, biological wars, pandemic diseases driven by habitat destruction, and asteroids, climate change is already irreversible, but Earth can be inhabitable. Beyond 22 plus wars, range with irreversible destruction, times rapidly, cascading global dimensions, slow stability, some forms of isolation, others allowing irreversible climate change, climate damage, joyous mining, agriculture, opposite approach, and habitat, essential biosphere, driving diseases, freshwater, imperial physics, extinction, like we can already triggered the irreversible greenhouse effect forces, summon human populations, including capability with increased rationales for use states and fossil worlds, playing vectors, disease, starvation, growing opportunities, mobilizing against asteroids, AI, and genetic tech running my fire weapons and demonstrated willingness to use all kinds of space around human like not like the working tiny resources in space now of course on the moon to make Earth habitable as abundant minerals to clean energy moving towards manufacturing way new tech companies that make feasible harming extraction will be negligible risk of that multiple abilities of Earth on the moon survival space and pressure legal terms for exploration be choices and will have to be equitable employment because of expanded and scalable support manner if humans are willing to work through intolerable layer conditions jurisdictional issues get complicated not any of us for private despite lack of clarity jurisdiction and like martial law legislation subject voice are treated employees private attempt to create uncertainty the confidence of establish jurisdiction and unenforceable employers jurisdiction top and in space labor disputes are inevitable competence and legal protection for CVRs prevents militancy from jeopardizing safety innovation but the 21 parties and not less labor market essentially used to protect the process of CD employees will strike space which are protected not only occur and not threaten a dangerous condition by TV supposed to be included in any point in space failure to settle for that provides records for employees by a dangerous mission contention to its human presence irreplaceable for safety critical missions enabling trust calibration and avoiding cognitive overload that magnifies human error to forward human oversight were made irreplaceable including not leading to judgment humanity racing theory critical work about the latency that offers conservation of high safety sensitive planetary protection cognitive development life originating for the logical estimation expertise committee would not be autonomy would rely on trust calibration adaptability reflex seconds the overall under trust accuracy performance and safety and persistent tension between atomic and cognitive demands on human cognitive overload situation where increase errors human Back containment existential, Hamilton and 22, existential risk versus flex convenient development, service back contamination, histories written with examples including microspectral epidemics, and basic species, contaminants have runaway effects and death, consuming all the earth's oxygen and chemical chain reaction, creating temperature emissions broadly, actually sort inevitable and unavoidable, like gamma ray bursts and solar spikes only sustaining human. The president enables risk diversifications in whole scale 3 gamma ray bursts can have to answer and destroy life across space. What catastrophic events supporting space travel from being wiped out by a single event like a meteor, the sun heating up, environmental disaster, natural disaster, and experimentation with radical strategies fails gracefully 22 scrolls and tests the accumulation of accidents for the two important use of leverage science which impels large race space office elbow to manage to safely manage the added danger to change for keeping the nucleus advantage constituent from the wider human project. Thus, the plan of the United States federal government should fortify collective bargaining against the presumption against extraterritoriality for workers in the United States, temporarily stationed on the Earth's moon, contention 3 solvency, clarifying labor laws, trumping power over presumption against extraterritoriality and enforceability. The moon arbitration resolves uncertainty and sets a model for workers in space decker, and without greater protecting the U.S. attorney around the jurisdiction, individuals are worried about being exploited without recourse. Companies are worried have no remedy. These will run the multi-million-dollar venture capital together. Jurisdiction will all that enforcement mechanisms in space instead of playing the rules adjustment. Thus, to take years in return, many will increase expectations after bad behavior to the judicial system in space offer way to enforcement and expedient and fair and ideal. Start of the moon, creating mandatory arbitration of the moon. Apply on top of laws applied extraterritorially via choice of law service jurisprudence to create the foundation of space offer generation. CDRs for key to recruit and retain necessary expertise. IAM and 22 critical maintain dominance not address will become instrumental in initial summer growing skill governance availability of action. Various work restrictions strong laws ensure hiring jobs are made in the U.S. and struggle use continue to recruit and turn in the moon fuel. Outside jobs paid by salaries and benefits negotiated by the unions and the force of the job shop. U.S. protection crew CDR training services. U.S. companies who outsource cheap labor working conditions suffer poses a threat job and loss skills that a company lost, leading to further crimes trying to use transfer duty and to ensure labor peace. Hogan and 22. There will be no remit before CDS enforcement existing legislation to charge exact status of working in space transit within their jurisdictional lacuna as well. A small specialized workforce able to leverage representation in a more expensive species economy with a large supply of labor, successful cross coordination, cooperation, serious jobs, enforcement, existing labor laws, difficult and the bargaining powers to administer without means of enforcement of labor rights, flexibility with disaster shockers, market, union, generic workers in the space energy, force manufacturers, scientific research with those in outer space, ensuring degree safety and autonomy.
Yeah, it's amazing. You've had it the whole time.
What would the workers on the moon bargain over to increase, I guess, the conditions that are insufficient now?
The same thing that workers on Earth bargain over for space workers.
I guess, like, what are you read cards that are like CBRs are key for expertise? Like, what about it retains that problem? Or, like,
the problem is not what they bargain over, it's that they don't know and think that they cannot bargain when they are stationed to the moon. So workers have the rights while they are physically on Earth. When they take a work trip to the moon, they lose those rights. That is bad.
But do they literally lose the rights, or do they just not think they have the rights?
Well, so the court has yet to rule on whether or not. So like, but space work, like we think that the president in the status quo is that they will not have it. Like if a case were to arise.
The reason bargaining is important is the same reasons on Earth. Like they want better work environments, like better pay. Like what is that? What is the interlink between those?
What?
Like, what are the things that they are bargaining for, and what is the outcome that they desire?
I mean, like Joanna said, like things on Earth, like better working conditions, better ability to, pursue their job.
I mean, historically, so there has been a strike in space. It was Skylab 4 in 1992. In that strike, the workers were complaining that they were being worked for 16 to 17 hours a day because NASA was like, we're only sending you up there for 2 weeks. We need like so many scientific experiments to be done. We have so much shit. You're only up there for a limited amount of time. So you're working 18 hours a day. Those workers turned off all their radio communications, threatened the entire mission. And then NASA was like, okay, we'll work you less hard. You get some breaks. You got 8-hour days instead of 16. That's an example of what they could bargain over.
Okay, advantage 2. What is the internal link between just broad human presence in space and solving things like bat contamination and the laundry list you've read?
It's about managing
The question was what, sorry?
Like the existence of humans in space solves bat contamination as well.
Yeah, the argument right now is that we are using too much like AI or non-human technology, which cannot have the human feel, right? Like an AI only knows what it's already seen before. The whole point of space is that it's not, right? Like we're going to go to asteroids that we've never been to before, or do missions that we've never done before.
Humans can see
because AI only knows the data that you've given it before, but humans are like predictive. We can like feel things out that robots just can't do. There's also a second internal link about cognitive.
What is the reason why feeling things out would make us more effective at managing
So if there's like a new bacteria, like say for example, like a new moss on like an asteroid that we're thinking about mining, right?
Okay.
A robot can only look at that moss and think, is it similar to a moss we've seen before?
Okay.
No, then it's safe. But a human can go, this looks fishy, even though I ain't ever seen it.
Who does the plant?
I mean, plants as use of G.
Normal means.
Least necessary means would likely be the court.
Why? Federal courts.
Federal courts.
Well, because the presumption against extraterritoriality is something that's cited in court. So probably that for like, we think the plant act is USFG, we don't think
Okay,
counter plants are
I guess-
competitive.
Advantage
Blah, blah,
one,
blah.
solvency, is it just the existence of US workers that deters Chinese action, or what is the plan's remedy to solve Chinese?
Oh,
action?
so there's a very specific section of the moon that is available for nuclear bases. If we get there first, then China factually cannot build anything there because it's overcrowded by US
It's
nuclear.
the South Pole.
Yeah.
Sorry. It's okay. I'm sorry.
Did you hear that? South Pole. Got it.
Confirmed.
Great. Nailed.
I'm lost.
Oh, no, not like in a way, but like highlighting one.
I don't have it yet.
I just sent it.
Okay.
It's 12.
Take a guess.
I'm gonna say 13.
14.
I was closer.
I'm gonna need a second.
Yeah, I probably would have said the line at 12 and a half.
How many are you gonna get to? 9.
That's a good question.
Wait, let's set a line.
All.
9 and a half.
Mine's 10 and a half.
10 and a half. Okay. Oh, he's confident.
Hmm.
Do you want to stimulate the number of dissents? Oh, is it 14 and then case?
Yes, and then one addition.
Is there meant to be nothing in the doc on the affirmative? Is that coming later? Are we getting like a supply drop? Or is it just like not safe? I'm not like,
No, there wasn't anything in the doc I sent out.
oh, okay. I just didn't know if you like got to take say before you sent
You're
it or
good.
something.
What's the doc I have so far?
Great.
Is everyone good?
Mhm.
Team workers means all. I love 81. It workers means all employed persons. They don't affect all workers, but negative alternatives of the flag against any small union of the weak after leading core guidance that may present an economical interpretation, killing research counterplay the United States federal government to set net legal collective bargaining rights in the United States by abolishing national power industry unions and fortifying collective bargaining rights against presumption against extraterritoriality. For workers in the United States temporarily stated under its moon, strike requires that affect and nothing whether this is effective rights from based on the effect of law. Private sector unions get competitive capacity for China and airport active 25 unions plus automation high wages. While you start production defense production unions retain and international aspects include aerospace and security second Boeing, as well as FFT and Air Force. Softly delivered to companies which China US not have ultra weight well or industries in security and leadership as topic airport insurance accidental adversarial broken breaking 24. Your super accidental for any operation ability defense of the law based including expect service CT individuals must combat China and her X-rays army development so fund Canada factions across China with residential conflict accidental we must ensure air security counterpart the United States president should promote the United States should ratify self-executing treaty that will find collective bargaining against presumption against extraterritoriality for workers in the United States organization under through the treaty especially that nation or parties are under I look venture 154 options for leaders to the fortification of collective bargaining against presumption against extraterritoriality for workers in the United States organization of the urging the United States Supreme Court also uphold the treaty as valid outside of the treaty. Power that can be dissolved by self-executing treaty or unstated binding. That's 42. Given battle United States survival tax and the time for both taking liberty, prosperity, including enforceability, and also United UC trade institution islands and forest racism before persuasion that same federal government employs are directed against state non-fair USC's reforms for team crimes globally was one word ratified. Committed by the island, they have obligation to work with resistance that ratify island rights treaty. Keep the law for those that their self-executing their 36 for resistance with protection. Power US government island edifice the IEL got 18 island was surrounded with commerce involvement treaties and provided by the globalization labor system on IEL and physical economic sovereign labor relations to island from global government to legally receive persons to be interested in the base success of as many level of the students to be certified for the jurisdiction of the US to be trust by law. Without those strong, IEL also teaches regular 23 years to come to national price wars possible and every country market trade for the economy north of it. Progressive political economic and policy for and evidence stable development for economic just certain food versus research based in kind of trade and investment diverse settlement continue to feel IEL intersect subject matter that IEL for within the full environmental liberation or water American action development in space for government of the times I must be generic. About to become mandated, counterpart the effective for limited constitution benefits for 5 collective bargaining against extraterritoriality for workers in the United States Federalization of the Earth, the Constitution rights all by 24 efforts every time. The right to the Constitution, the law, contracts, and oral terms, protect rights to bargain. DA. The court will narrowly rule for now it's COA and in terms of the gestation labor line is second to 30 how 121 court line into the court on the draft and get a relation to the fact that court line is removed after the and will be the dispute that allegations of negligence robbery frustration of leader process order remain while the case in the library various processing tower considered as a recession capital if prosecution of independence of the fact that down remove wrong within the decision by summer balancing is ironclad the competence not to choose 5 allowed 25 true working battle very written competence which are using out of the way of learning such as the rules of capital liberty and the marriage and one no truth and no substantiability court line solvers remove by under road or arm with larger by capital 10 hold the for ruling statutes of common book 20. Issues under what force of the extent which Robert's was under considering because about order country justice and going to grant lower burden labor. Area court like that the body was the use of CC there's limited speech under PC. Under your ruling for Trump the last round fed independent tax $1,000 has 25 Trump the fire code. That's the independent factors central law corporates are limited the average tax budget and these are goes on the pressure. And bringing the market for governments will be Trump putting the president in control of the American look like Venezuela or too late for the world growth if it has to be 5 times extraordinary. Both of the end of the Ukraine that company in Russia around the US pushing and Africa the first of all time creating survival of the US and the individuals from the world all considered class use and floated up. It does end up being structured to be corrupted. There was everything over the US back to the back to the President of the finance military social safety and export dollar. To be critical to the kind of the source of I'm grabbing leverage and finance things regular numbers. We're going to look for years to come. Count on the United States federal government to the time to welcome sexual for regulatory bodies that bind the return for the presumption against the territoriality of the United States and the else for between the countries provided this punishment. Public enforcement including illegal wage trading and cooperation with we're in this organization for ourselves out of the program regime, positive participation, that's the 23, reverse working, which number line workers leverage and political power to raise, and it's working for the CB workers here by wages down in the person counter and have a rock happening, those in the wood and places, CB sanction, including the CB workers with the one, to record that users try to work the more violence leverage, CB covering against the law for the and by wage, border basket of the beverages and combat from the CB, for regular workers, extra regulatory duty that was passing from parts of the government, in quote, other areas, and receiver line negotiation at a level work for a line marching into law, our response for evidence and attack for markets, local government, and office on the ground, discrimination of the other areas, and as an engagement of American government represented, the government empowers into the circuit regulators on multiple factors of random clouds, extension, Mark 21, there's a hard levels for the interactions used, research allowed third party political whistle, socializing energy, publicity, financial, reputational safety, institutions, reserved by agencies, circuit regulators, partisan, and circuit accountability, comments of public regulators, academic transfer, battery, something or system, phosphorus positive, T, the United States jurisdiction in areas not needed is code in the United States, it's specifically geographic presence that fits into the United States, the court factors are with the United States based on the United States Supreme Court that the United States is using constitution, limited states again, but they violate the works in the move, vote negative, it's only after extra source, so application, and take laws, trade out the knowledge generic, DA, the United States federal government should determine the president of the act of the National Labor Relations Act are not separable. The entire MLA will be invalidated after the end of the labor insurgency. And this sort of preemption allowed the union focus AI safeguards loss of frontier trying to end away and entirety of insurgency. Fuel tape for next to what legal rights have federal budget and energy and money union joining the practice and free states. Preemption A will be rights and liberty on this alternative from TV organizers. That's some safety because the U.S. United States country AI allows how to legal lower cover by this. Law labor boards legal by the federal CPRs are subject to the white craft enforced by the war. That means they're both have to go to the law. Federal labor law board 77% of the structure of white first happened to CBO majority of the wages and 81 percent. This needed and no given cause by had to oversee your CBT AI safety losses 25 unions for legislature oversight unions for safety and provided because of the need labor green yellow or whether they have to use right plus right against the AI for regular market by government government first as a safety understanding AI for labor market extension just 24 with AI extension if it's a relevant power like great but for capacity the person capacity that also needs to cost the revenue integrated as well so then it has some regrets that I don't know I'm not finished about the nuclear resource from the near her customer was working with the makes it in the worst of the alternate potential weapon of passage makes that more accessible for any critical labor with customer find the actual time of repair models with 20,000 government challenges operators with control associated with HIV Navi independent smart cloud military especially with actually chemical waste via SL4 left go right and tax of waste T collective bargaining to kind of the cost negotiating with their employers barter labor in organizing including structure excluded Sentinel 13 CPS and everything thousand video pages effective the allocation working to defense agreement with and activities to be done having three languages about that and already defensive LMR being the CPR roughly about values to the right form services or the hunting to be the project negotiations distribution to be and other activities to be outside of replacing against the right for running well first should be rendered there that's the division labor giving Congress and include that the violence right to system down within the right market because they protect rights for their evidence advocated for a sort of reference from 1 to vanilla 21 vote nag 1 limit over the popular our balance that they rights last in harmed industries the mechanism 2 ground for DS and kind of assume marketing midterm CA United States federal government should actually skip all that jump to now market 326 in sort of a reference for planning and the incredibly negative work for economic populism average 25 condition and policies workshop for good this is making the working class kind of mission party rights for really taking the work as economically progressive for the digital last conference will do this for progressive conservative concept taking any lost independent government to find general this candidates with economic progressive with Congress and party west capital definitely possible to dub cost 45 and kind of entry people GD to do and ecology as well as be not be politically fixed by measure of the cost of the disease no actually the GD exchange of Roman 25 GD and high confidence in transfer crossing on a measure of sanity size of like artists of the order with terms of increase miscalculation because and satellite children automatic confidence in secretary perception and because we saw computer trade is a vulnerable accurately resources diverted attention and funding for various such tried by several and vital that 100% that state press is more like organization the challenge to ensure the United States for commercial argument and report for the bargaining for the result of against secretary for works in the United States Association on the Earth's mood. Advantage not of the United States federal government should determine that the mood has been the right to enforce the United States obligation to the United States Treaty and preclude the highly enriched union uranium on the mood. Advantage 1. The OSC solves every impact of this case because states are cooperative. Common grace have proper 19 states have not recognized the access or revolutionary railroads that they creates the escalatory pressure so it deter about to be talking about towards the escalation of the OC supported the a peace for growth state and for concentrating religion and moderate behaviors also denied the self possible state of course those to be consequences discriminate impact on assets impact on both environment impact on earth that is not accidental actually you can't read that card no space for. David 21, analysis of company and saying attacks on his own level, right around the corner, says 9 to log records, technique of other. There's a losing competition based on which breathing hard to operate. There will be opens in all seven because it's limited long trade into the arts and better all seven to operate them. Red Arms big position, no China war shipment. 320 G removal plus not put like over cost military data inflated needle removal equipment. Reducing big target data to our armaments on top of that to address social issues. Original activity to mental feelings training and readiness training. Comment and Buddhism is not you any cashiering of the season officers have applications of readiness. Also returns to activity purpose that mission for them on they abide by it and you China abide and if you the nuclear first strike by China, Spain doesn't meaningfully reduce center risk for Site 23, so it's causing like crossing river survival on like those crossing rivers are intermittent border to the ethnic national risk is 1 in 10,000, but overall risks are at 1 in 6. It's hard to see how it's going to protect against risk that super as movements you can control life lifetime still some of the commercial conflicts that group of scientific places and every still human rights can imagine very the passion they on the ground that manifold jumping the risk that pessimist needs no reason research is distinct so this card also is advantage, answers advantage 2. Go to advantage 2. There's no solvency. Human presence can't mitigate every excess. One is the last card that any threats are emerging from face out and discover your presence doesn't guarantee action. Population spread. Caps back intimidation. Farquhar 17 headers are like a concentration of the planet and that's 4% word disease, non-word global of our species and new versus sort of people response to the capacity of the host with face out. Pressure to go evolve. I'm just going to send everything that wasn't in my bag.
Yeah, wait, can we wait for like all the case and advantage counter plans and
It's all the same.
okay.
Yeah, I didn't read everything in his doc, but everything that I did. I didn't read everything in his doc, but everything I did read.
Yeah, I've looked. So we're good. I usually do. Sorry?
It wouldn't surprise me.
Wait. This is the. I thought so. This is the advantage counter plan that you read, but I thought there was a third plan.
There were 2 planks like that.
Oh, okay.
No, you're thinking, it's fine.
Okay. I must have misheard. Wait, let me copy paste this into the one and see, please. Okay.
Good.
Yeah.
Status.
Status code is always much flash.
Net benefits.
Okay. The Boston's counterplan is internal. The treaty's counterplan is internal. The Concon counterplan is core politics. The co-reg counterplan is the internal and NLRA strike down.
What's the benefit to the counterplan you only read the text for obligations?
I didn't read that.
Wait, yeah, what was the like loose?
Okay, I read the delay plank of it.
Oh, just the delay.
Just the delay plank of it.
Yeah.
I couldn't make out what you were saying.
That was the last thing I said.
Okay.
Like I skipped the counterplan.
Got
the delay plank.
Okay. Reasons to reject the team independent of T in the ones.
I don't think they said anything.
Okay. The court politics DA. Is your argument that the court has no idea the effect of like ruling against Cook has on the economy?
I mean, like our evidence says that ruling against Cook would have adverse impact on the economy.
Yeah, and
the court
I'm
might
asking-
know that, but they place a much higher weight
The court,
on
okay,
constitutional
so
legitimacy
the
and
argument
removal
with the
power.
court, as you're internal to this
uh,
DA, is the court cares more about their internal PC than decimating the entire economy.
I don't think our evidence says like justices don't know what their impact is. There's obviously like different evidence in the literature about whether or not this impact will have on the economy. We've
Okay,
read
you
evidence
said it has
would
had
have
an
impact.
impact.
Judges don't necessarily know that, and also our evidence
Why?
says they do care. Judges don't know the impact, and they don't really care about the economic impacts of policy because they're constitutional people who care about legislature and statutory authority and the ability for the president to remove agency members.
The sever or like NLRA Act not severable. What evidence says that NLRA will be struck down now?
The philosophy evidence.
Where do you think this card says will be struck down?
Our evidence says that it will be struck down now because of the removal protections that the federal government is going to rule against.
No, read me a line that substantiates the removal protection card for argument. Like this is just a card that's like, if they struck it down, everybody could do movements. That'd be so great.
Well, it does say if they were to strike it down. I mean, the counterplan would cause the NLRA to get struck down independent of this. But because it determines that provisions are not severable, so any one chip to the NLRA would cause the entire act to get struck down because that's what the counterplan feels.
Okay.
The conflict fiats that the provisions are not severable from one another, so you can't strike down one part of the act without striking down the entire thing.
Okay, the offsets counterclaim, how many CBRs does the counterclaim?
The counterclaim gets rid of a lot of CBRs because it bans
Count them?
CBRs in.
How many?
It gets rid of CBRs in national power. It gets rid of CBRs in national economic power industries, which would be many millions.
Many millions. Okay, how does your card determine, how does that?
Like if you make an argument about how many workers the plan affects, we'll read evidence that says this is how many workers the counterclaim affects. It's more than double.
Yeah. It's 9/11.
He lives in Atlanta, but.
How's that possible? See, here he goes. Have a good time.
Do you agree that Atlanta is
Yeah, it's part of it matters. Like he said it was.
part of that?
You gotta go, then go.
Fine.
No, yeah, that was horrible. It's not bad.
No, that's also just.
It's not a good way to stop. It's not a good way to stop it, but that was pretty awesome. I can see that fault on my part. It's pretty.
Wait, we set the line at what, 9.5?
Yeah, I'm gonna.
11, I'm pretty sure. Fucking hope so. Right? We set the line at, or was it 10.5?
10.5.
Damn, I think the over barely hit.
Oh,
Countermatch with the advantage counterclaim.
Dude, I lost so much money.
Did you take the under?
I took the under.
Oh, okay.
I put like $500.
That's not good.
Wow. No faith in hobby, guys. That's really messed up. Okay, order. I'm gonna try and go slow. Moon, human presence, which is 1 then 2. T subsets. T in the US. T no strikes. The ILO treaty counterplan. The co-regulation counterplan. The con-con counterplan. The offsets counterplan. We're good so far? Okay, the advantage counterplan. The court politics dissent. The ban NLRA counterplan dissent. Midterms.
Can I get everything after?
Everything after what?
Co-reg.
Yeah. Con-con.
Okay.
Offsets.
Okay.
Advantage counterplan.
Okay.
Court politics. Ban NLRA counterplan plus dissent.
Yeah.
Whatever the last thing is, midterms.
Okay, give me a sec to get the doc open, but we're probably good. Yeah, we're good.
Ricker? Okay. OSD doesn't solve the US doesn't follow what it happens on the moon agreement that's Decker, even if we did, OSD does not speak to labor conditions, which is also Decker scratched no space where they said yes, space more and both the notes, they're procedurally disallowed for reading this, but it's wrong, moon-based sabotage or accident S3 perception that it's already militarized and that its E3 assets will be next undercuts deterrence which causes miscount, and Russian nuclear war that's FA and the economist, yes, China war using the space race to China collapse CLA go because they'll weaponize new hard power and economic coercion, dismantle institutions and start laying wars that's work in Richmond. They drop the title as revisionist and wants to win space war, and that only one country can get there first. Their evidence not assume space, and they don't just say first use because it will do great under disrupt NC3. Space call isn't in fact, it's having humans in space. It does solve it. Sokolsky on advantage chooses that there are 7 inevitable threats, including things like gamma ray bursts, which ensure that extinction is at some point inevitable and prioritize structurally at. They drop 3 impacts first. Reactor accidents cause extinction, hazard uranium is prone to melt down, and any accident essentially nukes the moon, which ends the Earth rotation that's gone through bonds yet gas. The second, which Earth terrorism and cause extinction. Attackers will hurl actions at the planet, which accelerates the gravity won't cause essentially climate change. That's nestful. Third, lunar resources solve all extinctions and prevent resource wars, pandemics, and environmental harm. Let's be no answers to any internal link means it's already try or die at human presence advantage. It's try or die for risk aversion. Many extras are long-term inevitable, but a designated survivor can preserve humanity's future. That's Sokolsky. And Grace, yes, back contamination will bring back deadly pathogens with new defenses, or new chemicals with reactions that consume all oxygen, which was dropped. Hamilton Farquhar is not Earth diseases. It doesn't answer chemicals. T. How to interpret no article means yes, substance may contaminate after the article showing you complex modification of variability, solar with variables, because the closely related to modification of relation to resolution depression. For 1 gram per position. As a matter of fact, it turns everything else. Second, F-ground, big side of an enterprise, industry, region, or words that are unpredictable. No literature. Third, mixed words. Whether or not everybody is expected depends on their choice to work in space. Fourth, no offense. Your advocates can't be equal, no bind the state's counterplan, etc. No reasonable best to be insured. That's reason about a substance. ILO does not mean that the plan has to apply to every worker, just that everyone with a job is a worker, which is the recutting. T in the US. We need 1. Plan is the only effective vector, and U.S.-based workers are key. Second, they're legally employed in the U.S. military, using the national the overnight as if they all routine travel, though as if they never gone to space. Counterintuitive U.S. jurisdiction, correction, and addition to graphics with all these jurisdictions. The U.S. prefers 1 precision. That's how all the literature works. That lots of Montgomery 2106, one German Senate jurisdiction, lost false go into launches in reality in the U.S. local jurisdiction, or by Americans, also many of the jurisdiction, all of them consumption, New York, back to by the U.S. part of second ground, artificially excluding it makes solvency possible because corporations are multinational across wide reasonability and eventual limits. The third team. We needed the app extends the CDRs that workers currently have into space, whatever that entails. Inserting an internal link card as the violation is the definition of mixing burdens. Cross-supply plan in the vacuum strengthen limits within existing scope. Tower 82 within scope applied to the CDRs that includes all of the RLA that's UL 16 CDRs, include all the animal sections concerning this right. Prefer a 1 precision showers in comparison. And UL topic authority second ground. Scope apps are worth for both sides, and no strikes is impossible for the app to predict. Third, over limits their interpretation ensures circumvention, or workers having no leverage. Cross-supply functional limits of reachability. I love. Perm do both. Perm do the counterplan. They must be textually functionally competitive. Anything else is arbitrary and unpredictable. Collective bargaining includes processes deviating to CPR and institutional relations between government and labor organ definitions of the overlasting to the relations system made up of such processes. Perm to the plan as the outcome of the counterplan. Perm to the plan over other issues. And that's good. It's necessary to test. If the benefits remain, perm to the plan as follow on. The counterplan is legitimate. Reject counterplans that include all of strengthening and bargaining. There are relationships from substance and procedure. Only the plans is a credible signal to multinational space companies that the U.S. specifically is the safest cave in stone. Mention the rest of the enjoy my position throughout the world. China is actively trying to outcompete on the basis which guarantees brain drain and capital flight against workers won't sign up for missions, which turns both advantages, especially for Trump, MIT. 70 Trump's under management credibility, especially hardware leaders, farmers, successful treaties, users, believe the president creating an agreement to why all the treaties which all cause from foreign policy, reversal, temperature, American sanctions, reply to vote. The counterplan is backwards, making up ILAW, only weakens it because the app is nowhere in the IEL, and it doesn't stop anyway. One shot holding doesn't establish a norm, which is will be cutting B, Trump thumbs, violating other norms, legal rights, etc. See their evidence of mental thinking. Most people don't believe in ILO anymore, which is the one you see. The bureaucratic card says extinction 0 times. They highlighted it like a haiku, but the app sounds better because they drop and solve all resource conflicts ever. Co-regulation. It gets struck down, Basman in 25 to regulation from problem receptions every time to the course, things have reproductions, the logical programs, the time to new cultures, curse, like warning the new subject, program from mysteries, reliable work, race, delivery to regulate sources, this is important, intended to solve it, to terms of CBRs, analyze, not public policy, and like warm, that controls, realize, and back machine is, and it fails. That's Basman in 25 also over, so you can ask the lot of best control, and smart relation, for second road, cool benefits, one, to increase understanding problems, you know, in the sector, identical, legislative, management, competition, so just rather than businesses, they come to all competitors, create this model, barrel century, business dynamics, and sectoral part, labor market. They just break up have never must do the Bureau of Federal liability structure news for from which conditions to break up results and for decision not figuring orders go right. Doesn't chaos, no internal net benefit. One, usage justice for lower. They said their evidence says could and not will. The US already tried it and said no, best in 25 performance. Second for relation and Russian throughout the LU, starting productive you, modeling with the labor very second property market availability 100 years later makes no sense. Second, global costs to environment impacts. But they dropped that the app solves them all of you know evidence. So we talk about perm do both and perm do the counterplan, perm do the plan, and then the counterplan. Should is not immediate because if I say, oh, you should do something now, that doesn't mean I should go get lunch. Talk about. Links to that benefit if it causes follow-on per growth. It shows because the plan is perceived as follow-on per counterplan right at 1922. The function stated in the red rank was known as constitution, function. It gets struck down, breaks the constitution, loses it. Continue to mention no more no can really show our application whether not commission on application will investment be limited to the grocery company review research functions or work with research that many certain authorities short of and law just reference conventions and competition before the course. Then convention work that being it is a voter. There's no competitive literature. It's never happened, which makes it unpredictable and unfair. Con is bad, streets are good to use research and strategic thinking. Voter for returns, offsets. Perm do both. It does the plan twice, once with the counterplan. Perm do the counterplan. It's plan plus. It's not suffering. The plan contains no resolutional language. You do the whole thing. The counterplans have to either be both textually functioning method. Cross by that will defend strength and CBRs, but not against offsets. One kills the gap as the whole plan, and the next any form of weekend, which is possible. Second, education destroys that specific and favor generalized. Part of the plan and the offset part of the counterplan. Stephen said the text it does strengthen CBRs just from other areas. There's no terminal impact. Their power is shot inevitably if we lose the space war, and therefore it doesn't say extinction, but China will overpower, which is an app scenario, so this cannot be external. Advantage counterplan. Perm do the plan and a foundational place links to the benefit because it causes the courts to rule on things so the public will perceive it. OST fails, it doesn't exclude labor rights, which is Decker, and banning nuclear also fails, it just ensures we lose to China, which is key to South Pole basing. That's forensic archive from the one I see, core politics. Normal means that the Supreme Court can deny cert if it's the soonest possible would be next document rule one for the news job. We don't be closing the Supreme Court to have cases in the current rather than the next fall. Insurance because of time generators like hot cases the court refuses grants fully general interview or next term. Those cases isn't most controversial or tell the docket. No spill over reddish 9 substance practical support from cases facing no reaction controversial cases based on this regulations of reasonable. These would be ruling related issues, terror slump, and the shadow docket based slumpers inevitable. It's a 6-3 court majority that's quarter. In 20 most Republicans talking to Republicans in 26 times only 3 courts suffering about behavior consider immediate consultation opportunities to rise both courts to majority further than immediate rules. For Trump, mark that X Trump, there's no terminal impact. Fed independence is the false. They're beholden to Congress anyway, or thumbs like suing Powell thumbs it, but the Fed is not effective in solving the economy. There's an internal the Fed actually mentioned common rules to reduce inflation, keep the rates higher, essentially do nothing about your inflation, they need to invest the best in Congress, economic forces, change the dollar, no impact. That's coincidentally the dollar for 80% check down, eventually can be constituted future trade of service subsidized as a barter. Mark that F barter, ban and array. Perm do both. It's not mutually exclusive. That's for change 26 dollars really kind of different spaces. Workers not falling under the any police ordinance that garlic is with air travel. Nor means would also be immune arbitration, which doesn't solve. There's no scenario for the impact that's from years back outside of the air. The first potential no scenario where ice continues that you use red up literally gas to all the new weapons. Aircraft to launch over the culture of extinction. The counter term can be any private sector laws, so T isn't a link to the dissent. Well, interesting. I already read that card. Prefers one position or evidence from the DOL and another after works for both sides because they lose to the state's kind of like midterms. The delay counterplan 1 proved to the F on November 4th, 2016. Inserted second delay counterplans means reject the team with SKU and education. Third proves it should not need you. They should have picked a different verb. Impact is appeared denied by the last 2 years. No work they don't. That's they didn't have any question was political political reality most organic politicians running to shoot goes when they meet to point being public. They don't care listener. If you can focus on fusions to the Dutch votes also more percent on that's little for space also responsible to the voters sex economy security with voters in space. C candidates votes campaign on and ground. In 24 voters with multi Harrison not from the impossible neither has to see here about as we're upset national to the moon has partial disease much 1%. In American the moon GOP win is likely now Michigan. In 26 people in dimension referendum on the person who's London or different there more in the state of March economy focuses on economic don't see percent to spend the only evidence from Venezuela around the short no Stephen numbers thing goes to real threat no one else will not decide that the poll results and black funds like foreign policy issues the plans unpopular so also in 24 conversations against their American tradition of education health and very excited so many things going on no impact other countries won't agree to host it but the app turns it because of its larger space it would take decades and no arms racing London 25 defensive really decades by extra basic challenges and your best friends solution talking about the West taking negative challenges constructing system fight versus the concept of builders like we're talking about for within basic fighting you need to develop and fully assessment providing less events so possible run trying one numbers of weapons. Mark it number of weapons.
Okay. Are you good for process?
Yeah.
Okay. Like, Kondo was the reason for the team? Like,
well, I said a bunch of theory.
Okay, yeah. But were they always in the argument?
Probably not in front of this panel.
Okay, that's fine. The co-reg counterplan, it gets struck down with Bosman evidence. It's about the Supreme Court striking down state-level co-regulatory schemes. The counterplan is a federal scheme. Who strikes it down?
The court says that there are 3 preconditions to avoid preemption, and
yes,
it's not
exactly.
gutted any of them.
No, it says to avoid federal preemption of state labor law. The counterplan is federal labor law.
Okay, like I suppose then, oopsies, I don't know.
Okay, cool.
The next piece you haven't actually really read a solvency card in the 1 and C, so like I suppose what the
we read a very
explains
expansive estimate evidence that says the case for sectoral co-regulation.
Yeah, but that card is also about states because we only have done it at the state level. So
okay,
we also
but the
read
count
about
in text fiance at the
right, so you don't have
I want to
solvency
talk about
advocate
the
that
next
actually
piece
says
of
the
evidence. It fails because it spurs strikes. Doesn't the plan also spur strikes?
No, you said labor peace is good.
Okay,
The plan
where does this piece of
prevents
evidence
strikes.
say that sectoral co-regulation spurs strikes?
Sorry, you're talking about which
The
one?
next piece of Bosman evidence.
Where does it say that it causes strikes?
Yeah.
The bottom part says that the results are never optimal, and the last line says descent into chaos.
Sure
That
to
kinda sounds
arise
like
from
strike.
state and local creation of mandatory collective bargaining codes.
Right.
That's definitely not the counterplan.
Co-regulation.
Because the
When it
counterplan
talks
kicks
about
out of
mandatory
bargaining.
bargaining codes, it talks about
The counterplan
co-regulation.
kicks out of
The whole
bargaining and
article
state
is
and
about
local.
co-regulation. Are you serious?
Okay, yes, but this line doesn't have to be. It
No,
says
the entire article is co-regulation bad. Of course, the part where it's like this would be a chaotic event if states and like
yes, but
other
the
governments
specific-
did the thing.
It also doesn't say the
Being-
plan causes strikes. Okay, I want to.
Descent into chaos sounds pretty bad when the one I see was labor, peace, good, and space.
Okay, that makes sense. I want to talk about the ban NLRA counterplan. This receipt evidence. It's about firing SpaceX workers. Why is that? What the plan?
No. So there was a labor controversy. The NLRBs like filed a complaint against SpaceX, and then in that SpaceX appealed, and the NLRB and the NMB both agreed that it is not NLRB/NLRA jurisdiction for space workers. This is binding precedent. It happened
So
in
the
the first week of
NLRB does
February.
not have jurisdiction over space work.
Correct. The NMB do. They're the people that do the Railway Labor Act. So like Topic Committee, Think Back, Railway Labor Act, NLRA. Those are the two big laws.
Okay.
NLRB is NLRB. Railway Labor Act is NMB, which
Okay,
stands
that
for
makes
National Mediation Board. Both
okay.
of them agreed in binding
Substance. Could
decisions.
you just explain no article means yes substance?
Yeah, so if I say the example the card gives is like if I am close to the lakes, right, the workers in the US, if I'm close to the lakes, that does not mean that I'm close to every single lake in the damn world. Obviously that means like there's a lake nearby and I'm
B
close to
doesn't,
that.
B doesn't modify
Workers in,
the US. Sure, we don't think you have to be the entire US. You think you have to be everywhere.
well, no, this article also says if it, like, it's talking about like a worker, right? But
that
given
also
that
is not
isn't
the
there.
US.
Right, that's our point.
You
So
define the
if,
word
so
not
no, the card says we're close to
Like
like.
you define
so
workers in the 2AC?
this card is explaining the grammar of the resolution.
Okay.
I also recut your card, so like, yeah.
10 minutes.
Yeah. All of them? Well, no, I don't.
Wait, no, not that much.
Okay.
That's,
Just.
yeah, that's not gonna put it.
Yeah.
Yeah, 654.
What? Like the facts count. They just sent it in courts. They sent it one all macros.
You said 654.
Yeah, that's
Just a bit from one.
Okay, yeah, I'm also going to use somebody to note that just the rest of two judges.
Yeah.
Let's see if you
It's all in like common sense.
Jesus Christ.
Amateur hour thing in the world. Oh.
Order is T workers. The co-red counter plan. Advantage one, advantage two. Yeah.
Wait, sorry, one second.
Yeah.
T.
T code red 1, 2.
Okay. I'm good.
Workers made up for work in the U.S. before one ability to build up to single agency research jobs like the EBI innovation data processing snack by subsets within subsets individual workers for your company that's new corporation removes the like policies and e-commerce community opportunity changes that outweighs purpose and use rethinking proposal relies on unrelated generic second precision the ILO sec guidelines for every country the human workers are to the gold standard carbon 14 zeros on the ILO customer principle outputs looking working and funded to US all the US and B7 and innovator the ILO is complicated for master principles of declaration general basis like more workers must be stored in full scopes so 12 general must another most fundamental the general must based on reality this is a basic compatible principle which triggers the first standards for 25 verb posts and including the back service or exceed notice report all notice exceed no notice principle of all inclusive agrees that assurance and no date this principle of all inclusive words without restricted class of class of all inclusive individuals my house or including all individuals my house or including all inclusive one of my notes are restricted class of one of the most basic rules of management predictability as a prerequisite to any office the meaning of the topic guides all basic reference corporation. Anything else allowed should be focused. The kill fairness. Now, the choice did not see meaning on this page did not cross supply or answer. And in a vacuum, it still violates the plan specifies workers on the moon and direct planning to the vacuum kills the list. And then beyond anything with additional language is unfair. Lower time later, putting down class B on the plan is characterized by types of process obviously was substantiated above this. Predictable and fair that you want to defend benefits next up. Inroads and debate is now this. A article thing is yes, substance is nonsense. The and A don't modify workers in the resolution. The rights restricted rights for workers for is not an article. And choosing costs explain as a precision argument. We determine evidence and defend all workers on position above and below, but they don't encounter vision of workers which is negative on jurisdiction. Recounting on card is insufficient because it can only flow negative, and they do not say countered by workers. So obviously that does not apply. The counter also fails independently except all lacks a record for exactly how many workers that causes global should be. And judging by since enough workers is ultimately a gut check substance obviously don't refer generic sequence 22 freshman equals mean the freshman E mean the other freshman other freshman world and set. Remember that for E mean this only sort of mean that ideas and freshman and sure be or false signs else easier independently. Worker fails to upward intelligence that workers bring the whole class of 22 tests. Distinguish 13 X throws the creatures upward intelligence more if we start this type of animal takes a lot of shit the animals on the line of of rate is false other words for means throughout words A means throughout as a natural grade. The same across the board and sometimes meaning was for more than local governments around one setting geographically. Because means all states EBA 6 geography means all states when you want sufficient modifies the rest of the rest. To apply all state coverage. Now grammar is neg that was done above. What we see it independence of everything else the phrase should provide for the actions normally desirable. Now requires the action of strictly regards to the universal across workers. In the US here before more questions for the language rational activity rational behavior. Universal rules more medical with also the age and because how they also accept anyone else to be that were more permissible just has been universal. Now background is wrong. Innovation is trivial. One advantage is that it's like automation equaling housing. From monopolies, immigration, democracy, workers will be or inherent economy-wide second mechanisms to get treaties. Delay regulatory and rulemaking or even conditions on trade or nature trust no impact on the news and healthcare. With that limits trade out to teach next season back next crowd outweighs the infrastructure find great vast structural advantages for peace selection seeking laws no public private issue, which was not even an argument made, but they can still say straight economy-wide sectoral bargaining with any combination of choice advocates or people. They use with the NRA after any combination of sections as well. Now this is inserted all sub advocates for reference, but that largely is relevant. Pigs are good. They produce regional plan specific to regard topic DAs. It's an advantage alternative to generic commodity counterpoints is also fair. Large advantages intrinsic deficits including industries. Refers to not solve international law, modeling, or monopoly advantages. Literature checks every pick and large enough to outweigh internet gaps. One universal keyword to be every pick, while the neg needs a new case net for every app. There's no mixing verdicts, nothing brings helpful requirement, and not being applied to all workers, which was clarified in cost sex. Now, functional limits fail, or I don't think they said this, but maybe on the page, but legal rules, interpretation removes all of it. There's no other constraint they can find unique features. The bar is low, the one thesis that cannot be factual, be generic, you not think crush research innovation anti-educational polemic. Now, reasonability is arbitrary, causes judgment prevention, kills barriers, not feasible. The direct topic of the already combination of all cases is closed, limits, no cut out, when the group sensible as possible. Teammates are good, they make education, wants to be teachers, are raised to the top. ILO is negative, and applies to all employed people, the plan does not apply to everyone that is employed in status quo. So obviously, it still flows neg, but they don't have a counter interpretation, so it is structurally all the neg offense. Now, correct counterplan. Correct also case in the panel sector upwards and worker changes. Is that employment standards in the food industry, which is what their evidence is about? Everything workers would demand. And the CBA would become a binding sector by rule of functioning against the outcome of utilization without the actual structure of a union. The first vast evidence about state co-regs not being federal being struck down, which obviously litigated process. The counterplan is federal level. Second vast report, the only counterplan that only does co-reg for mood workers, which is what their evidence is critique because their evidence assumes the abolition of all about labor law, but regardless, sexual regs that is not unique because America already has jurisdiction-wide standards like minimum wages and safety laws, and workers don't think their own industry is fine trend. And enforcement of this is good everything error, which we're about to find it. It's usually the lessons history is way by going to the setting of the servers going to make America. Most of the industries which they are vetted, sexual rights are fine-tuned and flexible, and it gives more suggesting example different training and experience in developed workers in government. No one complains from higher work organization, including regarding U.S. and benefit wages for this. These all workers who made those spread from units by higher standards and have a voice. The Tracy basically not even working keyword. Most of it was sexual reasons bad, but not a reason why the plan necessarily is good. So obviously directional offense is neg. The counterpart self spillover. It's spillover to participate in democracy, having workers devise and enforce public regulation. Scientific participation requires a template for analogous cases, mainstreaming a model of democratic administration which citizens themselves are principally responsible, which is the Andrews evidence. Unions cannot capture that benefits of the rural workers as private negotiators as the circuit regulators, and they did not say the conflict doesn't solve just what the plan does. So I'm not putting this extra card. US says no, it's wrong. It wasn't binding. This is our argument. However, we should abandon the LRMI, which is obviously the DA and the White House plans as a model that goes global, but the same way they solve the environmental global is by we would as well. I cannot solve either because we need to pursue democracy and internal because only that democratic input makes sure that we can effectively constrain the environment, and only we obviously have defense the case ability to do so. Pursuit democracy does solve democracy. One, enforcement. Regulators are under resourced citizen policy involvement, flags violations, and imposes regulational sanctions offerings that flat environmental goals. Now, do both things to strike down, but it doesn't solve the eternal one. Crowd out, drop in the tag, and red verbally. You want to see workers have finite time and energy, the plan keeps them trapped in conventional price bargaining. So they can get what they want from union negotiations, whether they're environmental, experimental standard setting. That's excellent. Second is redundancy. Boost 22 introducing inherently by many decided past time energy and modified energy design to have low tech policy on the behavior of policy and that also can as an institution that produces energy to continue participatory practices. Office defense trying to put those best participatory law making only risk of permanently rails. Give cap suburbs. Secrets of process right. They exclude substantive provisions. Secret teams reverse right. This is the correct number of colleges figures out if the price of agreement capitalist political law interest. The workers law have understood the right for the labor point authorizes sources of membership of union law based procedure. The place to advocate claims the rights of creators of individual like actions to the labor law district at least is a regulation which employs employees to voting issue law and political laws act and this areas of topic to include everything from worker play regulation and guts and ground with the core topic generic. Now, other issues needs to strike down, but they also do not send a text or hold the line to choosing an incomplete argument. And you should not allow me to point out answers, but it's the vagueness for 17. Evidence based from agreements from the policy and mandates for two answers apply to play. Although we invest worker time and resources in a complete federal labor regime that trades off on our focus, we're talking about locking out the union directive arguments that show papers open alternate units, pushing it towards local and locals, unions and over the group workers local instead of federal that doesn't it's independently intrinsic. It doesn't happen in an area covered by advocacy for functional competition, especially against the affluent graphics. Limit all generics and possible burden against them. Second, logic, textual competition, short opportunity cost estimated, implies opportunity to serve or to lead phrases to create opportunity advantages for borrowers like not sponsored. So the plan, free education, deficit, the actions, contract card, memory, uses of voter, viewers to clarify what other issue with sending text is or reason to reject them. To lay purpose intrinsic and has temporary separation between the content of plan, each case can be laid as the sequence to be by either rejected intermediate, shows all ground and public truth, did not include a formal text, so strike it off your flow. It's average. 18, the worship is mandatory speaking my now, as labor time because not as spiritual now, the choice cannot be card. So one year will be new, preferring to lay just by science fiction or the education of science ground. Worst example to apply the labor method is good enough theoretical grounds or being with sensitive advantage. Now, CBR key is wrong. Just labor piece is in only the evidence is about expertise as shifting a voice on the ground. We obviously solve that because the conclusion of the evidence or as 23 rights to organization is supposed to check our bodies for regulation of local graphics, the intervention rights for workers and devising and posting standard rules for you just have valid responsibility for workers and photos for police or work hard to speak to legal times. This also goes to the responsibility for state work together also with power by engineering and submitted replacement. I just been so good to replace it for job security, financial employees, replacing the consumer energy to the social and the environment impact outweighs breakdown in ecosystem services, create for crashes, food web, water cycling, and biosocial resources needed for organising life as worker outweighs on magnitude, often dialects, counter impacts, but you can't negotiate with the environment, pursuit of working to solve corruption, save 26 as a negative. It's true, corruption, modern and fill offices, local social street, law enforcement, reduce corruption, extra wisdom, the teacher, cost people, working there, something, answers to the workers, and dealing with social transgressions, the way to reduce the living, like the local corruption, criticism, and check reason, benefit, corruptly, general, or the major risk, which is necessarily outweighs the advantage one. OST does solve if that's OST should be submitted to solve because it's finding even if it's covered labor is the reason why China would want to cooperate in the first place. Also, you have to say yes, no space for since there's no risk in the first place. The countries are seeking to cooperate in an unfamiliar region in the source mode. Even if they were to attack each other's satellites and others like that, there's no reason that they would escalate to nuclear level. There's no China war in the first place. They won't weaponize anything. These are too structurally deficient arguments starts from like a week ago. It says that they are facing purges, etc. HT is not confident, which means that it zeroes visionism in this context because even if he wants to, he doesn't have the capacity to do so. Space called just responsible because humans in space scale. The choice he pivoted was that it's about presence, not about the living there. But obviously, living there wouldn't solve it. Just merely being there obviously doesn't either. It doesn't solve extras either. Nothing about intrinsically being a space is more likely to solve because we can easily do it on Earth. And also nothing about space is unique in the first place, which will be largely done on advantage too. Also, China no more capacity that was done above no LIO China intent twice actually advantage two. Present alone cannot solve. No reason humans would innovate against it in this part is good. Sure, Earth created necessary innovation in the first place. No back contamination. There's no 60 microbes in space. Microbes on Earth are evidence about population spread and fatty cats. And the double-blind if it's trying to kill, it would die with the host. So even if our evidence is about alien stuff, there's no reason without it was a 5% Earth.
Good.
Yeah.
Okay. I want to start on T. On F ground, you said you could use any combination of statutes. How is that topical? We asked us to be all the statutes. No? Is there one like you said they have to be any combination of statutes? That's not true. Right?
Our interpretation is that it would apply to all workers, which would include multiple statutes.
But not multiple, all.
Correct.
The RLA, the NLRA, FSLMRS, the other FSLMRS, all of them.
That's not a reason why. I don't understand.
Well, I just mean you said the opposite of what I understand your interpretation, so I'm clarifying. When you said they have to be any combination of statutes, that's not what you meant. You meant they have to be all the statutes.
I think we meant to say it must be all. That would clarify the question.
Okay, great. Co-regulation. What happens when there's a dispute?
So
A worker is on the moon. What happens?
The card I read under voice says that there are mechanisms for them to express disagreements to the board itself.
What mechanisms?
It says that they would create standards themselves to impose duties onto other people. So
What is the appeal process? So like
the existence of the board itself guarantees that there is an independent regulatory body that would probably oversee.
What does the board do?
So like in the same way that unions would sort of leverage and resolve disputes internally, they would just use that.
No, unions don't resolve disputes. I read a card, well, I inserted part of a 1AC card for reference that the act causes moon arbitration and that is the only thing that solves. So when they're on the moon, what is the board? Is the board on the moon?
Insofar as the act creates an extra body, I don't know why that's a reason co-regulation also does not create the same board.
Well, are the co-regulators on the moon?
I guess, like, I don't know why this would be relevant if it's just about.
Well, so I'm confused about the appeals process, right? So something happens to a worker. For example, they make the worker work 16 hours a day. The worker files an unfair labor practice. What then?
The counterplan creates proactive regulatory labor standards through facilitating worker input.
Well, Card, have you said that private space companies on the moon will comply with that? Well, if it's just the regulation counterplan, the preemptive regulation counterplan, what Card says companies can.
The plan also establishes a separate arbitration mechanism. There's no reason why the counterplan cannot either.
No, you're not
Because
answering any of my
the
questions.
internal link to arbitration is not unions themselves.
Okay, yes, that aside, when a worker is on the moon, the employer makes them work 16 hours. The worker goes to this co-reg board and is like, hey, they did this really messed up thing. What then?
The board would implement a regulation that prohibits that.
What Card
from
says
being
companies listen, and what Card says workers trust that regulation.
to the same extent that the penalties implied by process of union would force companies to
No,
agree.
because the 1AC said unions key, and we said regulations fair. That is
Yes,
a 1AC claim in our policy
for
cards.
unions key is workers being able to express discontent via
What?
voice.
Do you have a card that companies listen to the counterplan? Real easy. You read the employment law counterplan. You have a card that companies follow the regs counterplan establishes. That's bullshit. Give me a card. Give me a name. Not every card. Come on.
Esland definitely says it. The 1NC.
What card says workers trust it?
Esland. Huh?
What card says workers trust it?
1NC Esland is citing empirics in states.
On
that say that
Earth.
they would obviously.
In states.
There's no distinction between them.
One second, bro.
Oh, huge. Thanks, Chris. Go. Yeah, I'm gonna go. Oh,
We took 26 seconds. So,
yeah, 26. So
28.
sorry, you said it.
Yeah.
So, okay, like, I guess I'll just do a long order. So it's the advantage counterplan. And the ILO counterplan. And the con-con counterplan. And the offsets counterplan. And midterms DA. And the core politics DA. And the NLRA straight down DA. And then the co-reg counter.
Strike down, and then co-reg at the end again.
Yeah.
To be 100% clear, the advantages were not in that order, right? There was a bunch of off-case stuff.
Okay, sorry. Okay. People good?
Yeah.
Wait, how many on the dot? Okay.
Good?
Yep.
Kicking the advantage counterplan and the ILO counterplan can see the permutation theory. It's a reason that the argument not the team and process counterplan bad. It's about co-reg. The co-reg counterplan picks out bargaining. The con-con counterplan kick it. Can see the permutation conditionality is good to get. We did one block two absent and two receivers require multiple option. They encourage the mechanisms on mass slash inserts two next as again. Next goes reaction after significant private destiny inserts is unpredictable advantages. Add-ons and deficits for arbitrators. No difference. Separating models, no reservation theory. Unpredictable worlds worse than none. Which always shifts the rule that predictability, non-disclosing this voting issue makes it possible for us to compare the three. Use ground is unpredictable for logic. Finds the best policy option. This three absent. They can plan to 5. basic risk aversion mandates, fallback to safety testing and experimentations, new and research, and have rolled up ideas and procedural systems, ad hoc conduct, exact too powerful, incentivize the process of placement, and cause of research development. The office confident KK concede the permutation theory, art, not team, the midterm KK concede impact defense, so plan solves can't be offense for them, concede the Billy counterplan, not going for it. The court politics KK concede impact defense, are not going for it. Same thing about impact defense, the strike down DA. I'm going to do no link first because they're obviously what they're going for. Do both fails it. They still uphold the NLRA which prevents strike down the status quo. They drop uniqueness in the NLRA is going to get struck down now because of removal protected, so you can justify the confident and still know the DA is unique. The plan at least involves the board. One, Top County, the Wagner Act establishes it as a sole enforcement mechanism of CBS. That's from Morris. Evidence any act that extends CBRs to workers necessarily involves the NLRB, Kennedy 5, and specialized extending CBR to nuclear works and necessary implicates NLRA and NLRB is responsible for enforcing interpreting terms bargaining rights are exclusively enforced with the NLRB and IWR 24 and places the rights of working collaborative rights are exclusively enforced with the NLRB. Their evidence has collective bargaining might involve multiple statutes. Our evidence is more descriptive of the plan because it says, quote, extending CBRs to a new group of workers necessarily implicates the NLRA and NLRB, which proves that even if they have precision standards about their CBR definition, only we have evidence that's conventional to what the way does prefer our interpretation A is functional limits and A gentle constraint we test all cases and refocus it based on after the board teamwork which maximizes class B is precision. Our evidence has intention to find and says that is a statutory question and reject act in terms of the state explicitly how to define an agent enforcer, which none of their evidence does. It says it doesn't have to be enforced by the NLRA. It does not say that it cannot involve the NLRB, otherwise they're non-responsive. See no often they say board because of field expertise, certainty, and predictable outcomes at worst, which are interpreted. If your interest normal means the plan might not be the board, but it most likely is solved often by making agent companies non-competitive. The NLRB will aggressively claim jurisdiction over ambiguous cases. Melissa 14 employers that will be chamber about RA and board the NLRB and recently applied to actual employer, action not previously been the concern of a board of creative marketing and legal maneuvering demonstrates clear that will authority from abroad. Reading the act, the plan is not NLRB wrong. Reject clarification is reactive. So there's an incentive to avoid class. They should have said NMB in the 1AC2 is post-plan involvement. Even if the act itself doesn't involve the board, you have to intervene and result in suits of employers. Both out. Put it the running in party can be forced to 8 years. One party sounds eligibility or obviously the election. Either can tell the board is free proceeding if the certification has employer not working. And to the board of the suits, that means that if the plan is able to create unions on the move, those disputes would have to be resolved by the NLRB because they're the ones that who can control union certification. The NMB is about SpaceX workers like engineers and stuff, which makes sense why the RLA applies to engineers. No reason that literal astronauts would be under the RLA, which is what they're when I see evidence that the plan is about. It's e-contextual and our evidence above on the top county link proves that 6 times CPR workers requires the NLRB. Their evidence is not precise, it's from the DOL, so which defines labor standards, not CPRs broadly. Our evidence is legally more precise than all of it is in the content of the CBR, and the positions I did above apply. They don't move to states, which is the only warrant that the choice institution give it. New in the 1AR, there are tons of deficits, preemption, DCC, specific subset preemption arguments, uniformity, and more. Our interpretation doesn't uniquely make the state's counterplan overpowered interpretation. Any private sector law links to our offense above and links to the post-plan involved itself, which is a link to the normal means of the plan. There's no moon arbitration. The reason why the plan shields the link to the DA, it still has to be enforced by the NLRA and enforced by the NLRB, which is the top county and post-plan involved stuff. I did above. NLRB is primary jurisdiction over all private employers and labor organizations. They 24 function the board of the board of whatever organization of the public. Basically, the work of broad jurisdiction revenue involves all private sector employees and labor orgs. The bar is the exclusive governing body of private sector labor relations. Bill 25 NLRB enforced NLRA exclusively governs private sector labor relations. Laws establishing CBRs are enforced by the NLRB. Paragraph 25 NLRB is the federal law establishing CBRs enforced by the NLRB. It's a legal fact protection of collective bargaining. Is the board knows they take conference and NLRA to protect the rights of CB NLRB legally purpose legal policy. Being the NLRB ensures it's upheld. 1 is fiat, section 25 NLRB not function those having the same words like personal rights in the EU as 2. Everything must go. Leaving a shred of federal bargaining chills state experimentation. Last 26 class of bargaining is contingent on the entire NLRA following different preferences and first state class relying on technical state to make confidence with the navigate preemption of a conflict of many preemption as a administration we avoided AI outweighs on magnitude unsafe system royalty to mass produce supervising misinformation. Nuclear command goals is the only self-improving access and avoids hard caps and escalation like mad irrationality that solve the case cycle time for case effect or speculative and abuse that intervening actors are effective systems that are already being integrated. Defense does not assume our internally coordinate organized labor operationalize the safety checkpoints by empowering workers to whistle. The revision of unsafe systems that's a blasphemous evidence. Therefore, your evidence that AI is unlikely to cause nuclear accidents that might be one of our impacts, but we have other impacts that we're excited to give you. AI risk extinction, malicious actions, intelligence explosion, and social disruption. Correction from state security sector unjustified the same thing different partisan. People know that there are small groups that are massive their tracking AI is getting harder to get hold of the disruptive factor that commonly appear by work and consume institution navigate them to some perspective. We see some of the so the COVID safety optimizes direction development and prevents existential system failure. Hegel 25. Proponents for competitors who direct are arguing verbal tampering division rallies the opposite of providing energy for data that high impact value damages. No one recommended algorithm to them higher civilized markets for writing this info. And cognitive work happening consistent testing and absence standard lobby to weaken regulation is trying to rules. Participants against attacking true models robust and secure issues legislative China sample not social number from deadline integral weaknesses very parts that accumulate over time. Go to the co-reg counterplan. The enforcement deficit in process does assume the counterplan is fiated. The text specifies stringent function and generally finance enforcement through sectoral regulatory bodies apply the same standards to the affirmative. Assume it's a paper promise. The threat of liability for employment violations ensures preemptive compliance. S14 for both CP rights and statutory rights is made in the better copy, not reference that induce employer to say that that's obvious and employment rights back by threat of enforcement. Induce employers to reform themselves in data litigation to put this one factor in the reform that enforcement litigation. Enforcement is often tax 8. Employment competence, multiple organizations, narratives, that's activity. If there's an NLP, the first degree, NLP, shall have offer waivers, measures, and immediate, but the hearing, the action, and reader, like, how do I have personal private rights and stuff like that, are not having NLP, are being visual based and inadequate. Enforcement, the United States federal government should establish a mandatory arbitration on the move. We get new counterclaims in the one arguments you have. Strictly and trying to block into constructive since it's necessary to answer outside making, especially in this state where deficits weren't explained but just inserted in gray and inserted new into the process even if you reject the confidence to the extent that mood arbitration is the result of the plan. Workers are asked for regulation to create arbitration if the plan also creates a mood arbitration system.
Wait, hold on.
Oh, sorry, yeah, you guys are.
Hold on, I'm copy pasting from the body, which is screen format. Sorry. And presumably that new kind of plan goes on the co-write kind of plan?
Yeah.
Yeah, okay. 9/11. Yep. Oh, Chris already gave me one. Oh, thanks. when you said like when answering like the state's functional limit, you were like interpret any private sector laws. I think it was like the last.
I was answering your GOL. Like your interpret of any private sector law links to our office above.
Oh. Got it.
Okay, 350. It's in.
I've actually also got some thoughts to share in card form.
From the order.
Yeah.
Okay. The moon, human presence, T subset, the co-regulation counterpart, the ban MLRA counterplan DA situation.
We're good.
Now, cool. China is supporting the moon agreement. They dropped their internal documents, proved they want to raise the U.S. in space and are revisionists, attacking satellites, cause extinction, how much control all NC3 systems, and they're really wanting to relax the deterrence because we think they're going to first strike, constitute, or lose their evidence. It's about attention to invade Taiwan, not about lunar revisionism, which is our total against existential background for human presence. Impact will continue the defense, but they've explicitly dropped the moon resources and moon terrorism, impact lunar sabotage, outweighs disruption, lunar nuclear engineers have the means and motive to destroy reactors because the transmitters degrade thermal exhalation, which is common, lunar resources circumvent planetary boundaries, and ego collapse, resource forces, disease driven by scarcity, which results every impact to every day and extended means it's only risk for offense. Now the human contamination, the human presence advantage, yes, back contamination, their pandemic even doesn't apply because their impact is about diseases that we couldn't possibly predict. Now T subsets T subsets are made our evidence is an extension of Carlson's work on bare plurals to the context of prepositional phrases like foreign workers in the United States. Minor Hyman 7, we reach accept Carlson's treatment of generic process conferring. Carlson agrees that four bare plurals can be read existentially from the context of an opacity-inducing operator like believes or for, which speaks to the subject's intent, the precise scope of what is necessarily opaque. Carlson in 77, the plural with zero article gives rise to only an opening reading. This approach is authoritative. Purpose in 22 Carlson Street read were made for a long time, except the counter term, no article before workers means it includes subsets which may not have subsets or bad one destroys. After no actually means because acts have to include random stuff like the public and private sector, economic, sexual bargaining, or secondary strikes become steel and overpacked. And after always because we start and then made two unbeatable picks every after. This worse is a pick that easier to come because you only need two cards and every industry wants the exact plus the next. It turns into big picks, good is not responsive, they still get them. Versus teams that choose to link or other contexts, encouraging research is relevant if it leads the app host, and there's no reason why unbeatable picks are inevitable because our term doesn't set a new floor. And worse predictable 3, it's arbitrary. None of the cards say what they claim what they say, and they have modifiers or context that clarify all of that outweighs limits because it ensures competitive activity and limits alone justifies counter on the other app in terms of function limits, like states to Trump or the copy econ double bind and case reform the logistically encounter company of the week apps that only take her yes was said that to see air app lack of applicants. Units in the dumps there aren't that many industries or CDRs, or they can probe and research the railway labor act except reasonability to use more has the causes substantive debating outweighs intervention and race to the bottom is worse for all other often jurisdiction is stupid because most winning impact to violation of the USFG does not mean all branches Chicago have not a single entity which is for the USFG has bodies, Congress, state, etc. Now, it isn't fair. There are no deficits, and that can always get ahead because of 99 versus 100% risk function limits. Counterinterpretation proves that there's sufficient ground touch interventions and now since everyone has a different version of the topic. Yes, they have 11 off to pick from. And chose T subsets, T debates don't mean we don't learn about the rest. Only definitions work or the counter plan concede no rest based theory with zeros app, but zeros don't disclose the theory, innovation, creativity, but they're good. Innovation, creativity, and topic evolution is key to grounding education, good prep generics, instant fact checking solver offense. Now, co-regulation, the counter plan is incredibly unclear to workers. Is the regulatory body on the moon, is it on Earth? Which countries' legal jurisdictions applies based on the members of the worker board if they're from different countries working for companies in the U.S.? Zero cards that will hand you the neck card off. To speak to this, in the case is massive, so the smallest risk of the deficit should be auto. Framing issue for all their sectoral bargaining solves evidence only assumes terrestrial worker boards. But there's no explanation as to how the counter will work on the moon. The fine evidence is wrong. It just says it's from 2010. It just says that workers might be able to comply, but does not necessarily make a proactive claim that it would be able to solve the moon. Andrews card just says counterfeit helps unaccounted wages, but never contextualizes as being overworked. Or the space workers trust the regulations of the ball code. That is an implicit reason why CEOs are key. And it didn't spend the capital and the space filter into the crap pile of the 1 and C ones where they jump between flows and intentionally sandbag their offense. So there's no reason we could justify it. But CDRs are key. 1, talent unions preserve worker voice, which boosts recruitment, and negotiate for benefits, which ensures retention, which is IAM. 2, otherwise lack of human presence to emissions. Or adversaries and workers. 2, labor strike only negotiation. The outset defeats conflict that otherwise causes unsafe. Missions. 3, remedies only CDRs create moon arbitration organizations without them workers lack enforceable remedies. For disputes based perception alone is sufficient to refuse to participate in missions, only ensuring safe control mission for employees to preemptively negotiate and solve, which is Nestle and Hogan. 22, remote the space these workers find themselves without a preemptive response. Conditions vary from habitat to habitat, so only bargaining solve decorates 21 from one moving facility to another lunar installation. Co-regulation causes employers to get flooded with conflicting requests, spiking costs, and causing mass uncertainty. Taking 19, this is when any employee request a raise, benefit policy, the following requests overwhelming the employer cost of to make by thousands of representation, eliminates the confusion, and conflict that commercial community demands regards all sort of workplaces, which answers the fine evidence. Now, there's no spillover schemes that the counterplan exist in the status quo, and they don't have an internal argument about why the counterplan's implementation in this singular instance is sufficient, even if they win. The impact of the plan conclusively solves it through all of our external offensive proofs. You should only vote after you vote. It solves 100% of the offense. The counterplan solves the cases. Workers handle their disputes immediately, and companies comply quickly. But internally, it's only about time and energy. But as soon as the counterplan must fail to waste their time, don't use sliding scale. The more it solves the app, the more we win the perp. So structurally only after redundancy causes the single above. Now, NLRBDA, extend DOL, CDRs, include the RLA and other statutes. Do not throw out everything you've learned the entire year because Michigan didn't want to teach 1 and C prep to read this out with a link. They conceded precision outweighs everything on T subsets. So I cannot win this debate because they did not make any precision arguments, and everyone in the room knows they're lying. The next top provisions are unworkable and must be rejected, even if this DA is debatable, especially since you know they have new app generics to discuss. Them just going back and pretending that the topic is NLRA only does not solve any limits or ground offense. It just artificially rigs the game for the day in a way that's actively anti-educational, actively in opposition to the entire reason participating in the activity. Fail, go to your decides, let's have a real debate. And this is not a Kennedy specifies substance later, which is the Kennedy insert, and the app isn't about a new group of workers. It's about a new group of workers, which is 1C cross 6. It's about NLRA, and so most, which is other evidence. Not the NLRB rule in February, they are not the relevant regulator for space. 2C, DOL explicitly says it not to be the NLA. The text is not limited to the NLA, or DOL in 16. The text is not limited to the NLA written without running application. We would have told you to ask for cross-links, and you would have known if you read the news in February. The one that sees them about astronauts is about space engineers, forensic archivists use that language, the ones that handle nuclear reactors, and DOL does define CBRs already.
the cards, or you sent those cards out?
Uh-huh.
Okay. Click.
DA.
Count on you.
Anyone not ready? Corruption outweighs tools and merits as the only by system risk that threat extinction, nuclear epidemics, climate only remedy by effective governance that is quote low corruption, creatively legal, further bigger risk of events of reverse causal, no trivial event even to the 1 hour means that 1% risk of spillover, and if 1% risk of a deficit to do both means that we all are the ones getting blind over corruption, which is something they have conceived as totally existential to know to where you have both parts on counterfund that is counterfund solves money actually like to answer this and that. So by myself, environmental reasons when we're going to exclude add-on because to solve by something external. This is totally external from the ways that you they may solve by an overshoot, they certainly cannot increase and reverse corruption. Now, counterfund's obviously proper. It solves the case. It creates a personal worker representation that adopts the same employment standards, the opportunity of bargaining, the things employees process, they describe things like people are bargaining with wages, working conditions, work hours, etc. All these awards between without the presence of the union, which obviously is sufficient to see what are one about talent and solve by the estimate evidence. Argument says that it would maximize points to the greatest degree, which is there in the link development portion. It's a funny CIM as well. This is the regulations that would give workers bodies as a middle ground to those workers, sufficient control in devising and enforcing their regulations and their choice, which provides them input, which is what their evidence is asking for. They can't secure the same material gains that they would do in a union just without, which means to be on the outcome of it, our team's the same incentive. For humans to go to states, which also that internal labor strike cannot be a deficit, will be mimicked as process for the board where they are arguing amongst themselves because you don't need to argue within and negotiate a union, but you can just secure the benefits with the outcome and the counterpart, which means that the rights are enforceable and enforcement obviously would overwhelm it. Now, the moot arbitration, this also might be done, but we read a new counterpart, the one in our and justifications for why it was good against this app, and same night their explanations, the one here convention to answer it, the Twitter is not this point, which obviously means that we can clearly just be on past this because the same way the counterpoint CPR, the plan CPR will result in a new arbitration organization, the counterpoint just be on it past that, so obviously we would solve this appeal to things on Earth are not in space, obviously we got to answer this specific counterpoint claim that says that it would obviously just do it on the moon, but that distinction is also meaningless because the way the counterpoint works is that the boards and regulations of course would be on the moon, so workers can argue and devise regulations there too. They have never explained if there's a difference in enforcement between why the space and Earth are different, so the two areas once again did not get any new leeway on this. The remoteness of space Earth means that workers find that the response is wrong for the arbitration board above because it would literally be in space. The Decker evidence inserting about conditions verifying is also amongst all of our evidence of sectoral bargaining is severely effective with the one area no correct answer because they can negotiate amongst themselves. If we have the outcome that would apply broadly, enforcement is also a crush for us. Drop everyone in our court again. No deficit. Companies won't listen to counterpoint should equally be applied to the case. The one two text specify that we should quote establish well-funded bodies to quote set binding labor standards with quote stringent punishment for violations. That's stricter and more specific to the plan tax and demonstrate solvency to the counterpoint. As the evidence says that the reason CBO's issue enforcement is that the threat of costly conflict for some employers to apply. That is quote obvious in the case of employment rights. So the benefits of CBOs are mimicked by our counterpoint. These are equally backed by the threat of enforcement, which is the reason why they induce people to comply in the first place. Litigation avoidance is the main factor that should be established at Title VII in the first place, which means policy is on our side. This is a DA to the plan since we read the part that one in our stats says that employment law galvanizes the sex better than the NRLA. The NRLA is quote notoriously weak relative to other statutes like the FLSA and Title VII for evidence is comparative. This is that we are not captured the NRLA's global pace and inadequate enforcement. The tame evidence about flooding request no impact, pricing costs or certainty, but regardless it's wrong. We're getting compliance above. Yes, spillover schemes are being used effectively and not assumed like an NRLA die, which is massive. The union is for us, but the government does spill over. Having workers devise and enforce public regulation to actively teach us so that participation which spills over across sectors provides a template for similar cases and mainstream democratic administration. And only we have evidence from one of the agencies that it does spill over. So reject unparty analytics. The unions cannot solve that because they involve workers as private negotiators rather than serving regulators. So only counterpoint solve. Now, environment also outweighs. Break down ecosystem services, not just food, water, and environmental resources here for organisms and life. It outweighs and counterpoint solves it the same as the plan does. The plan solves once again. Litigating the law cannot solve the corruption stuff, and the United States allocation, but no reason it applies here. Now, permutation to vote is the only possible thing. One, redundancy creates an overlapping regime and ensures worker participation. Drop from the 1 AR, no new answers, drop time and energy trade-off. Workers only have so much energy to engage in different participatory structures, so they cannot engage in unions and co-regulation at the same time. Two, drop the links to strikeout. So we never showed that benefit. Often sequence is obviously negative. They drop a counterpoint claim that literally feeds the endpoint of the app. Now, the TA proper. AI always drop that mad and violations, success code, we cap there, and that's AI causing teachers skeptical, have terrorist space work because mutually assured instruction attack, no case solved. Drop that. The magnitude of CT failures, internal language, safety failures of the plan. It never solved AI specifically. The plan must include the board. 1. Top calorie. Extending CBRs to new workers must include the board. Our novel evidence is good as it gets. It says that, quote, any extension of CBRs to a new group of workers necessarily implicates the NROA and LRB. This is responsible for, quote, enforcing and interpreting all of it, which means that that means that the plan, which especially extends CBRs to a group of workers that is currently uncovered by the NROA, must be enforced by the NROA topically. Our NWR evidence says that this right to bargain collectively is exclusively enforced through it. That piece of evidence. Prefer it. 1. The next is a gentle procedure ask. We will ask. And refocus the debate on ask the board keyword. Conceding substance against any amount of workers. I mean, try or die from that ground. The board taking the board DA is necessary corrective for the massive amount of cases that they would get. There's no offense based on this. Same board keeper certainty. Feel that's these precedent reasons. Check those debates are good because they encourage legal nuance. 2. Precision. Evidence as an attempt to find CBRs in the context of the plan. It says extending CBRs to new workers implicates it, which means that it is the most contextual use to what we need the definition to do. They can be right that CBRs are generally applied to many statutes and many different legal precedents, but extending them to new workers must require the NRB. Conceding precision outweighs means that if there's a 1% chance, our term is more precise than the DA is 100 and you go neg, whether or not precision or functional limits outweigh irrelevant, because we have the bigger eternally to vote. This is totally the same from normal means. It says that procedural you to inflate the risk of a link to the DA due to topicality. You can win either with wings, swing, ultimate, and NRLA. So they conceded any 1% risk. Now, the app is a new group of workers. It extends CBRs to workers that don't already have them. And there's a many fraud case. 2. Normal means the NRLA must exist in the world of the plan. They get drawn in to resulting disputes and aggressively assert jurisdiction in order to maximize the amount of labor cases. They drop so much. Hold the line. Material sound good. You must fight one of your arguments. The material evidence says that NRB is increasingly beginning applying to private court policies. They use creative marketing, legal maneuvering to demonstrate the board's interest and wield authority expansively. Drop that if the app is meant to create unions and the NRB get drawn in because they're the only actor that can control union certification. Drop uniqueness friends a leak that early is certainly shut down now because of removal protections. So 1% chance that NRB is to get drawn in via normal means leak cause distinction because the DA gets yes, no, it makes it hard for them to make this 51% risk of leak outweighs and guarantees the t-shirt.
315. Yeah. Right?
Yeah.
315.
conservative.
Sorry?
Yeah, good.
Yeah, all of you. Okay, scare me a little bit. Losing this power certainly causes station 1 hard power. They control all of lunar space, including satellite communication, NC3, and early warning systems, and missile defense. They would have trillions of dollars to fund anything they want. Until now, China has never had the edge in conventional military power to control the United States, but winning the race gives them an overmatch. Second, soft power, the economic origin, not only can leverage the prestige of being the science and tech leader of the world, but they can sell moon resources in exchange to both military bases on other countries or invade aggressively. That causes extinction. They'll be more aggressive in gray zone activities, claim territory, including Taiwan, with armed force, disrupt U.S. alliances, and determine step away from peacemaking duties, erode democracy, and ignore risks like climate and inequality, the sum of which certainly causes extinction. Have never answered the terminal impact. The terminal obviously contains zero defense, so all of that you must take as gospel. You know that China is resistant and is actively trying to unseat the United States. That is a novel threat that has never existed in China until now. They are actively building a new moon space program, but the corruption has existed since literally like the first private corporation Adam Smith ever, so you know that it must factually be tried by act because the convergence of all of the risks that China will cause to the world must outweigh corporations being somewhat evil in the status quo, because you know that none of that has any uniqueness. The counterplay. The 200 began with you drop the terminal. Let me review all of the terminal impacts that exist in their card. Nuclear war, turn, pandemics, back contamination turns it, climate, the environment, no impact turns it, artificial intelligence. Our card says China will do it. The lower down it says societal challenges. Okay, pandemics again, and then climate again. This is not an external impact. Every single word that they highlighted is also present in the 1AC, so you factually cannot go negative on try or die. Corruption is external because every single word that they have, but none of these are even scenarios. They're just individual freaking words on Michigan, so you know that this cannot outweigh the affirmative because our impact must encompass and turn a given they have no defense. China LIO also causes more corruption because the state owns all the corporations and they're doing whatever they want with them, and the counterplan has no way to solve globally, but the app does. The environment stuff, also the app solves it. They've never had an answer to the case, so this must be a wash, must be turned in better because if China gets to the moon first, then they will weaponize all of the environment resources against the United States. So our standard turns there. Now, the counterplan does not solve any of the affirmative. The 2R was sauceless. Michigan has strung together a list of topic authors who failed to contextualize the counterplan to the affirmative. We're going for the talent deficit unions, which are more voice switching, no increases recruitment capacity. The IAM evidence says that stronger levels ensure higher paying jobs remain in the U.S. and stronger unions are critical. Any risk that the counterplan doesn't increase recruitability means we sacrifice the lunar resource base to China, which ensures they lead the world order. They drop the one tank card, which zeros the counterplan solvency. Since in a system like the counterplan, where an employer can request my raise, benefit, or policy, and overwhelms blurs and increases the cost of order factually said zero words. You cannot piece together the debate on their behalf because they messed it up. It means the counterplan just creates a massive backlog of employee requests for things that might become the outcome of the counterplan. The employers functionally cannot respond to them and grant those benefits because of how many requests are happening. Increasing worker voice alone cannot solve. What I see from the ES is that empowering unions is specifically key because failure to provide a legal framework provides mechanisms to fight China, which increases the risk of strikes and makes China competition inevitable. Let's stand firm to both. The firm solvency increases as the counterplan solvency goes up because the reason it shields a net benefit is the same reason that the counterplan solves the act. In other words, the link to that benefit is workers waste their time with labor disputes, but the counterplan solvency is no more labor disputes. They drop this explicit judge instruction in the 1AR, so the firm and the counterplan move in tandem. So a 0.1% risk of a solvency deficit means the firm has to outweigh because the tutor didn't answer this explanation. The only answer to the firm was time and energy, but no time or energy is spent. And the counterplan just solves all of the affirmative. I'm not conceding solvency, I'm just explaining the way that you should evaluate the permutation, or the counterplan doesn't solve the app, which means that it does look for the time stuff, the redundancy, the warrant in the card is also just time and energy again. So it certainly answered. The last thing that they said in here was that unions didn't solve it, and that is wrong. They've never actually contextualized the warrants of the 1AC, but you know that unions do because they ensure that workers have voice in disputes and that they can actually be enforced on the moon in the proper way. 1AC evidence is hyper-specific. And then again, when you open it up, we'll have literally zero cards about space, so you should probably hear it out, which is why we broke new. I know, right? Giving massive leeway in the 2NR because the 2NC contains two basically opposite T standards. The 2NC on T substance did not answer precision because they wanted to go for grammar, that the 2NR went for debatability, but contained no impact after this thing. That means that I get to pick whatever I want and you must take it as gospel because the 2NR didn't even try to clarify what the hell you should be doing. With this double T mess, you know for a fact that the topic is not only the NL or Michigan's model would have you believe that every single debate you judge on the Fed Workers Act should have never happened, even though we were all at the topic committee. Now, this is just the truth. Precision is a fact, and you know that the affirmative, so we did not need to line by line 11 1AR cards to say the same shit, because they're all out of context, and you know that I'm not lying, but Knowles evidence, which is that it is only about the NLRA. So no fucking shit. It says that the NLRB does all of it. It also intentionally says not all workers are covered by this. So you know it's out. The plan does not extend CDRs to new workers, which is the only precision standard that 2R contained workers. Workspace workers already have rights. When they're on the earth, they just lose those rights when they take a work business trip to the moon. This was explicitly clear in money process, and we hashed it out. So the only card that they actually reference in the 2R is affirmative. They also drop functional limits and reasonability from T. So the link to this must be 0. I do not care if they have a uniqueness claim. You should evaluate this link as yes, no. Only we have cards about the real world, the SpaceX, and the NMB and the NLRB ruled on SpaceX and the Tracy Bridgie evidence that it is not their jurisdiction. So you know that the literal truth in the world is that this link is factually 0, and they cannot topicality lie their way into building it. That also answers the argument that NLRB is required or that they're going to gain more jurisdiction, because the NLRB literally ruled in February that they don't want to deal with commercial space, only we have a card and they do not, and you know that they're lying, so this just can't be a net benefit, because it's not.
Yeah. We should never judge them workers.
Goodbye.
So way back here.
Yeah, do whatever you want. Wait, Steve. Come back. Sorry.
Okay. On red families.
So this part of this is all. Yeah. Oh, I suppose for the live stream, it was a 3-2 for the negative.
Yeah. And I remember just thinking that you were like such a talented and hardworking debater in lab, and I knew that you were going to be an incredibly successful debater in college. You're kind of just one of those debaters that you kind of get a feeling when they're in high school, you can just tell that they're going to be really successful, and that certainly came to fruition. You've had an incredible career. It's been, remarkable to see your growth over the past 4 years as a debater, and it's so clear to me just from observing from afar pre-rounds that in debates where I've judged you in, pre-rounds in debates where you're going up against Emory teams at award ceremonies, and even just now, it's so clear how much the MSU team, your teammates, and your coaches revere and admire you, and I think it's for really good reason. You're one of the best people we have in the community, just in terms of being a fierce competitor, but also a good person, and it's been such a joy over the past 4 years to be able to judge you and to be able to watch you grow. As for decision stuff, I basically thought that the DA was 0. I didn't evaluate any of the T stuff. I thought the debating on it was pretty incoherent between the 2NC and the 2NR, and I thought that the evidence set was quite poor to establish a link to the DA, and I thought that the risk of the deficit was sizable, and I thought that their evidence on deficit was better than some of your evidence of debating on solvency.
Yeah, I mean, I'll echo everything that Cedar said. You guys are incredible. I've judged you a lot. I've always come away ridiculously entertained every time that I judge you. Even if I vote against you, I mean, we think you guys are awesome. It's been such a pleasure to judge you. And I thought you were incredible in this debate. This app was fucking awesome.
Yeah.
We were just reeling about how incredible you guys were throughout this entire debate in our secret DMs. So, yeah, absolutely a pleasure. You should be really proud of your career. My decision is similar. I think that there's a risk of a solvency deficit, in particular this thing, which is just participatory regulations create issues for companies which could potentially lead to labor disputes. Significant risk of a solvency deficit, and then I was also 0 DA. I think that the app is allowed to define what the plan is. I think the plan is the RLRA. The neg is only relevant evidence about the NLRA, and I think the T is just substantively a crush for the app. So 0 DA, some risk of a solvency deficit.
I don't do public emotion very well, so I'm going to probably just roll my way through this for a second. I think that you are amazing. You're probably the most frequently talked about person in the case squadron for the last 2 years. You've single-handedly taken 6 years off of the Brain's life. And you probably know how I feel about you because of all the joking about how I should have to prove myself in judging. So there will be more to come, but that part of it's fun. On 0 DA, counterpoint solves better, or internal net benefit disruption. We could talk about more if you want, but okay.
I'm the only person on this panel that has the great pleasure and displeasure of debating. You know how I feel about debates against you. You kick my ass. You're a fantastic debater, even greater human being. I just love judging you when I got the chance. Doubles. I thought the 2 AR was absolutely fantastic. The affirmative was fantastic, and should be really, really proud of all you've accomplished. And I really need that you as well. My decision was that I thought you did. I thought that you won topicality, but they had a separate link to, even if the app was not the NRLA, that they would need to, and I thought that meant that DA app was a risk of a deficit. I didn't think that there was an internal net benefit.
Sorry, you did or did not?
Did not.
Okay.
It's a real shame that this is the first time I'm judging you all this year. And I kind of volunteered for it by seeing you all debate in the last one and being like, oh my goodness, this is amazing. The 2AR was fantastic. That from a debate ethos perspective is one of the best speeches I've ever seen.
Thank you.
And this was the best debate I've judged this year, for whatever that's worth. It has been a real honor to coach against you all. You've continued to challenge our students And it's always absolutely, an understatement to say it's a formidable opponent seeing you all on the other side. I'm sorry that I have not gotten to judge you more, and I'm sorry it had to happen like this, but truly, it was just an honor to be able to be in this debate and judge you, and I really appreciate the opportunity. I am with Ricker. I agree to dissent 0. You have a card from 26 that says the NLRB backed off of getting involved, so I don't see why this card from 14 means they would. But I do think the counterplan solves nearly all of the case, and I think that there is a risk of the internal benefit and that the firm would concentrate on.
Yeah, I mean, I've got I've got questions, but why? So thanks everyone for saying that.
For tea.